Stay denied. BVI Court of Appeal reaffirms threshold for a stay in $40 million shareholder dispute. In a previous blog post, we discussed the first instance judgment in the Phoenix BVI litigation, where Justice Mangatal considered the formalities for becoming a shareholder under Section 49 of the BVI Business Companies Act, Revised Edition 2020, BCA. That judgment has now been appealed with an accompanying application for a stay of execution. On 27 February 2026, in ICM SPC v. Jarvis, the Court of Appeal refused the stay. The judgment restates the C-Mobile Services Ltd versus Huawei Technologies Co Ltd criteria for stay relief and offers guidance on credibility-based appeals, the limits of using stays as leverage in foreign proceedings, and impecuniosity arguments. Background: Phoenix Commodities Private Limited, Phoenix BVI, was placed into voluntary liquidation in April 2020. The joint liquidators, JLs, settled a list of members which included Ancile's Special Opportunity and Recovery Fund Segregated Portfolio, ASOR, a segregated portfolio of ICM SPC, ICM, a Cayman Islands company. ASOR disputed its shareholder status, arguing that neither it nor any authorized agent had agreed in writing to become a shareholder. The judge at first instance dismissed this application, finding that ASOR had so agreed through its representative. The JLs subsequently issued a call to ASOR for over $40 million. Call. ICM appealed and sought a stay of the first instance judgment, order and the call, though it later narrowed its stay application to the judgment and order only. Meanwhile, the JLs served a statutory demand on ICM in the Cayman Islands and filed a winding-up petition. The Court of Appeal's decision. The Court of Appeal dismissed the stay application with costs. It applied the 5 settled principles from C-Mobile Services Ltd in determining ICM's application. Consider all circumstances. Treat stays as exceptional. Require cogent evidence of stifling, apply a balance of harm test, and assess prospects only where strong grounds exist. On its appeal, prospects, ICM failed to demonstrate a realistic chance of success. While the appeal raised questions about the interpretation and application of Section 49 of the BCA, the trial judge's findings were heavily influenced by credibility assessments. In particular, her observations that ICM's main witness was inconsistent, incredible, and convoluted, and appellate courts are traditionally reluctant to disturb such findings, absent exceptional circumstances. On stifling, even if ICM were wound up, then the liquidators could pursue the appeal if they considered it meritorious. ICM's evidence regarding its concerns that a winding-up order would result in reputational harm and irreparable damage to itself and a second segregated portfolio fell short of demonstrating that those fears would actually be realized. On balance of harm, Phoenix BVI's creditors had waited nearly 6 years for the liquidation to complete. Their prejudice from further delay outweighed ICM's. While a winding up would mean ICM's death, liquidators could pursue the appeal alongside their other duties. The court was also critical of ICM's true objective, using the stay to influence the Cayman winding-up proceedings. This had unflattering optics and amounted to seeking a coercive measure in extraterritorial proceedings. In any event, the BVI judgment has no binding force on the Cayman Islands court. It is merely persuasive to be treated as a matter of judicial comity. Finally, impecuniosity was not relied upon, but the court observed that any such argument requires cogent evidence of means, failing which the application would be irremediably undermined. Practical implications. This case affirms the 5 C-Mobile Services criteria for stay applications. 3 key takeaways. First, appeals challenging credibility-based findings face a steep uphill battle. Absent exceptional circumstances, appellate courts will not disturb them. Second, courts will scrutinise the true purpose behind a stay application. Using stay relief to gain leverage in foreign proceedings will not be tolerated. Third, impecuniosity arguments require cogent evidence of means. Anything less will irremediably undermine the application. David Chivers, KC of Erskine Chambers, Jeremy Child, and Janelle Stewart of Harneys acted for the joint liquidators.